Welcome back to Future Solicitors, and today we venture into the murky world of exclusion clauses, those sneaky little sentences buried in the fine print that try to make sure you have no one to sue when things go wrong. Smart solicitors, they draft this. So, an exclusion clause is simply a term that limits or removes liability for breach of contract or negligence. Think of those phrases like, we accept no responsibility for loss or damage or anything that goes wrong. They appear everywhere. Parking tickets, I saw them in Manchester. They exclude all liability of damage. Gym contracts, and yes, even dry cleaners, that we are not responsible for any damage happens to your expensive waistcoat. But while business love them, court have always treated them with suspicion. Why? Because left unchecked, they let one party break promises with impunity. The modern law now tries to strike a balance. It allows freedom of contract, but not freedom of exploitation. So our job today is to work out when exclusion clauses bite, when they backfire, and when Parliament steps in with the legal equivalent of absolutely not. Enough is enough. So, incorporation of exclusion clauses. For an exclusion clause to work, it must actually form part of the contract. The court will ask, has the clause been incorporated? There are three main ways this can happen. The first, by signature. If you sign a document containing the term, you are bound, even if you did not read it. And the rule comes from already discussed case of Grocco, the famous case of a woman who signed a contract for a vending machine without realizing it excluded all warranties. When the machine broke, she sued. The court said, you signed it, you are stuck with it. Second, by notice. The term must be reasonably brought to the other party's attention or before or at the time of contract. That's what we need to understand, before or at the time of contract. And that was in Parker's case. A ticket with the term printed on the back was held valid because the company gave reasonable notice. And you will find, like, you are buying a ticket, someone with their pen or pencil points, is a this is something that we both need to follow as a term. That by course of dealing, if two parties have a consistent history of using the same term, those terms can be implied into the contract even they don't write it at specific time. But here is the twist. The more unusual or harsh the clause, the clearer notice required. The rule comes from Interfellow Picture Library, where a photo agency try to charge a client £5 per photo per day for late return. Said the court said that's outrageous, and you did not warn them. Moral: the nastier the term, the bigger the sign you need. You need to signpost it, point it to the other party. So timing is the key. The clauses, like for example, if the clause come too late, it is out. A couple checked in, then later saw a sign in their room saying the hotel was not responsible for stolen item. The contract had already been made at reception, so the clause was ineffective. The clause must also appear in contractual document, not just a receipt. So a man hired, it is Chapelson case, a man hired a deck chair, got a ticket, and injured himself when it collapsed. The council said that ticket excluded liability. That we already said it, we will not be liable. But the court said the ticket was just a receipt, not part of the contract. Modern versions of these problems appear in online contracts. Oh my goodness, you will find a lot of them. Court ask Did the consumer have a reasonable opportunity to read the terms before clicking I agree? So yes, your endless scrolling matters, at least legally. Yeah, for example, those are very font 2 size terms or written on 29 pages at that point, and you need to just go and click it at spur of moment. Of course, court will come and rescue you at some point, but not all the time. Construction of exclusion clauses, that how to construct them. Even when incorporated, the clause must actually cover the breach in question. Court apply the contra pro forentum rule. Any ambiguity is interpreted against the party who drafted or relies on the clause. If you drafted it, it will work against you. It is the legal equivalent of you wrote it, you deal with it. When a clause tries to exclude liability for negligence, the court used the test for Canada Steamship Lines case. Ask three questions. Does the clause mention negligence? If not, are the are the words wide enough or broader enough to cover negligence? If yes, could they refer to something else instead? All of that three. If there is doubt, the clause fails. The court expect clarity. If you want to escape liability for your own carelessness, you must say so plainly. So we are not responsible for any damage whatsoever. Might sound bulletproof, but in law, it is more like an umbrella full of holes. So next thing is fundamental breach and judicial control. So once upon a time, court tried to stop parties using exclusion clauses for really serious breaches. They called this doctrine fundamental breach, and that's what you need to keep in mind. In Valley's case, a car dealer delivered a vehicle that barely worked, missing parts, not roadworthy. The dealer tried to rely on an exclusion clause, but the court said no. An exclusion cannot cover a breach that destroys the contract's whole purpose and performance. However, in House of Lords, the House of Lords eventually, retired this idea in photo production versus. So, in photo protection case, a security guard set fire to a factory and relied on an exclusion clause. Like at that point, the company relied on exclusion clause. The court held not because they approved of burning, but because the clause was clear and negotiated between the commercial parties. So if it was clearly negotiated exclusion clause at that point, it might work. The moral fundamental breach is no longer a rule of law. Whether a clause covers the breach is now purely a matter of interpretation and where relevant to statute as well. So what is statutory control on exclusion clauses? Like when Parliament saw businesses writing contracts with more exclusion than promises at that point, it stepped in with Unfair Contract Terms Act 1977. So I would be calling it UCTAX, or the Act, as it is uh, affectionately known by no one at some point, So UCTA applies mainly to business contracts and introduces the reasonableness test. So under Section 2(1), you can never exclude liability for death or personal injury caused by negligence. Not at all. Section 2(2), the loss or damage may be excluded only if the clause is reasonable. And Section 3 says if one party uses standard terms, those exclusion must also pass the reasonableness test. Like it must be reasonable. So you can't exclude liability against death or serious damage. Section 11 gives the famous test. The term must be fair and reasonable in all the circumstances. So factors include bargaining power, availability of alternatives, like whether the customer knew about the term and whether insurance would cover the risk. In Smith's case, a surveyor tried to exclude liability for a negligent valuation, and at that point, you need to understand the clause failed. The reasonableness test was not met because the buyer was an ordinary consumer relying on professional advice. So the UCTA ensures businesses cannot hide behind fine print when the playing field is clearly uneven. You can see that those big companies are, they have your backs of solicitors who are capable like you. So at that point, an ordinary consumer, it must have protection of law, and that's why we got this act. So the next thing is, so for consumer contract CRA 2015, that's what we need to understand. CRA is Consumer Rights Act 2015. Once again, I say, so at that point under section 62, any unfair term is not binding on the consumer. The test of unfairness is whether the term causes a significant imbalance to the consumer detriment, for example, contrary to good faith. Section 65 makes it absolutely clear you cannot exclude or restrict liability for death or personal injury caused by negligence, and that's a full stop. So, under Section 68, it adds that all terms must be transparent, written in plain language, and easily readable without a microscope. So you can't write terms into ancient Latin or Anglo-Saxons and then rely on them. The case's First National Bank case confirmed that like even seemingly standard terms can be unfair if they distort the contractual balance. So if your gym contract says they can change the price whenever they like, but you cannot cancel, congratulations, it is a classic CRA candidate. So at that point, you need the law will come and help you. So core cases we got we have discussed in this session and the previous session are Grok like a case that is signature. Once you put it, that binds. In Barry's case, receipts are not a contract. In Interphoto case, unfair surprise clause require clear notice. Like if it is like big thing, it needs to be written clearly. In photo production case, fundamental breach gone clear, exclusion upheld at that point. So in Smith case, exclusion failed under UCTA, and in First National Bank, fairness under CRA assessed objectively, not subjectively what party thinks. It is not what party thinks, it is what a reasonable person would think in that case. So if you think at least 3 of these cases at that point, like, if you can, you don't need to memorize case at that point, but you need to understand what they decided. So with common tips and pitfalls for SQ exam, always start with incorporation. Has the clause actually entered into the contract? Discuss timing, notice, and form. Was it clear and fair or not? Apply contra pro random. If the wording is ambiguous, then apply all those things. And most of the time, it goes against the party who has written it. Use Canada's steamship to analyze negligence. Distinguish between business, UCTA, or consumer comes under CRA contracts. Apply the reasonableness test and fairness test to understand, and you don't need to once again memorize the laws. So pitfalls are assuming all exclusion clauses are valid. No, they are not. They cannot be enforced. Forgetting that notice must come before the contract. It can't be after you sign the contract. Mixing up the rules for business and consumer contracts. The both are different things. Ignoring the fact that fundamental breach is no longer automatically invalid. So at that point, all of it you need to keep in mind. I will strongly suggest go back, and once you don't understand a session, go back and just go through it again. So one thing you should remember, examiners love structure. So at that point, your answer must be structured understanding, and you can build your structured understanding but by going back to this session. Thank you very much. Ta-da.